A recent federal court just put an injunction against the ATF, preventing them from enforcing their new frame receiver rule against companies like Polymer 80 and their customers, which would seem to include FFLs. So when the ATF came out saying, look, FFLs, you have to enforce this frame receiver rule, does that mean the ATF's in violation of this court order? We're going to be unpacking what's going on here in this video. But before we do, there's a giveaway going on right now. It's absolutely free to enter, and you can check out the description box to see how to do so. It ends really soon, though. I can't tell you what it is because the algorithm would get this video banned, but it's something that, punches remote holes and goes in a holster, something like that. Absolutely free giveaway. Be sure to check that out. Otherwise, here we go. So the Act defines the term firearm in 4 different ways. A, any weapon, including a starter gun, which will or is designed or may readily be converted to expel a projectile by the action of an explosive. So I'll reword that. I know it's a little tricky. Any weapon, including a starter pistol, which will or is designed or may readily be converted to expel a projectile by the action of an explosive. So we're not talking spring guns, all that kind of stuff, okay? B, the frame or receiver of any such weapon. C, any firearm muffler or firearm silencer. Or D, any destructive device. So for those of you who may have been wondering why silencers are treated as firearms, here you go. But such term does not include any antique firearm. If you want to know more about that, let me know in the comment section below. I don't think I have a video up on that yet. Now, importantly, Congress delegated authority to administer and enforce the act to the Attorney General, who in turn delegated that authority to the Director of the Bureau of Alcohol, Tobacco, Firearms, and Explosives, more commonly known these days as the old ATF. So in 1968, the ATF promulgated, they created a rule interpreting the phrase frame or receiver. The rule defined the frame or receiver of a firearm as, quote, that part of a firearm which provides housing for the hammer, bolt, or breech lock and firing mechanism, and which is usually threaded at its forward portion to receive a barrel, end quote. So in other words, the receiver or the frame, we're basically talking about the hull of a Mr. Potato Head doll, and then you plug everything else into it. That's basically what a frame or receiver is. That's how I generally explain it to people. That's kind of the gist to this. Now, in the decades since the ATF's definition of the frame or receiver, this definition basically remained in place until the very recent enactment of the ATF final rule in 2022. And the agency has not made any indication that it was changing the course with respect to its interpretation of this definition. Indeed, on at least 3 separate occasions over the preceding 8 years, going back to approximately 2014 or so, the ATF actually confirmed that Polymer 80's products are indeed not firearms for the purposes of the Gun Control Act. So once more, ATF moving the goalposts. Then, as I already mentioned, in April 2022, the ATF published a final rule changing, among other things, the 1968 definition of frame or receiver. And again, important, they're not changing the law, they are reinterpreting the law. The rule took effect on August 24th of 2022, and the ATF basically split the phrase into 2 different parts, assigning the term frame to handguns and the term receiver to basically any long arms or anything effectively other than a handgun. So we're talking about rifles and shotguns. So together, the ATF then defined the terms frame and receiver along with the same lines as the 1968 rule, though with updated, more precise technical terminology, so the ATF would claim. So in the ATF's position, they're simply clarifying things. But of course, the ATF did not stop there. Rather than merely updating the terminology to reflect modern industrial terms, manufacturer and distribution and marketing terms and so forth, the ATF decided to regulate partial frames and receivers. Under the new final rule, quote, the terms frame and receiver shall include a partially complete, disassembled, or non-functional frame or receiver, including a frame or receiver parts kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver. So in English, what that means is basically, look, a frame or receiver includes a frame or receiver as well as things that are not frames or receivers. So we're talking things that could become or may become frames or receivers, which if you seem a little bit confused by that, believe me, you're not alone, because basically so was the judge in this case. And don't worry, we're going to get to how the judge is going to take the ATF to task for this. Now, the ATF did bracket this because they went on to say that, quote, the terms shall not include a forging, casting, printing, extrusion, unmachined body, or similar article that has not yet reached a stage of manufacture where it is clearly identifiable as an unfinished component part of a weapon. As an example, unformed block of metal, liquid polymer, or other raw material, end quote. Seems rather generous that the ATF, at least as of 2023, is not including liquid polymer, i.e. liquid plastic for you kids out there, as being a firearm. You shouldn't be laughing. When determining whether an object is a frame or receiver, the ATF's director is not limited to looking only at the object itself, however. Quote, when issuing a classification, the director may consider any associated templates, jigs, molds, equipment, tools, instructions, guides, or marketing materials that are sold, distributed, or possessed with that item or kit, end quote. So again, the ATF, when they're reaching their classification, they're basically really targeting how things are marketed. Like, let's just call this what it is. They're looking to see how things are going to be packaged, marketed, and sold, as well as how things are going to wind up being used. Because at the end of the day, the ATF understands that if people can't buy things because they don't understand them, then in essence, those things are never going to be sold. So we have to basically clamp down on how these things are sold and marketed. And if we can do that, we can basically end this. Again, I'm not supporting that. Just calm down, keyboard warriors. I'm just letting you know, I think what the ATF's reasoning here is. And I'll give the devil their due. I think that that's an effective strategy. However, it's not necessarily a legal one. So how will the ATF determine whether an object or device is readily, their words, readily able to be converted into a firearm? Well, basically, there's a multi-step test where they're looking at 8 things in particular. So the ATF may consider relative factors such as, number 1, the time it takes to convert. Number 2, the ease it takes to convert the item into a functional frame or receiver. 3, the expertise required. Number 4, the equipment required. Number 5, the relative parts availability of any extra parts that need to be used as part of the assembly. Number 6, the expenses of doing all that. Number 7, they just say the scope, which I don't think we're talking about rifle or firearm scopes. I think we're just talking about kind of the scope of what we would call in law the totality of the circumstances, which is to say kind of like this nebulous, all-inclusive, like, well, the scope of putting everything together. And number 8, the feasibility of pulling this off. Obviously, if it is requiring that you go out and purchase a $1 million fabrication device or some sort of machining bit or some sort of expensive and proprietary lathe equipment, probably isn't going to happen even if all the parts are included. But of course, if it's highly feasible that somebody could do this in their own garage, then game on. From the ATF's perspective, all the parts are combined. You now have a firearm. Guys, I hope you're enjoying the USCCA channel. I know that I do. If you want to see more specific content from me, ex-state prosecutor Tom Grieve, then check out the pinned comment in the comment field below. That will bring you over to my channel where you can find me talking about all sorts of different things. Also, don't forget about that fantastic free giveaway that's going on right now in the description box. Now back to the video. So basically, the ATF's new definition of firearm shall include a weapons part kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to expel the projectile by the action of an explosive, end quote. We've basically taken what the statutory definition is of a frame receiver, which can be treated as a firearm, as something that is, you plug in some parts like the Mr. Potato Head doll and go. And now we've moved the goalpost to, well, if you can basically readily, feasibly, all that kind of stuff, make the Mr. Potato Head hull, then now game on. But there's a really important distinction that I made there, and the court's going to pick up on that thread in a moment. But first, how did we get here? What was actually happening in court? What's the decision that just dropped? Well, the judge is going to take up the question of whether or not there's going to be an injunctive order issued here, which does not mean that someone wins the case or isn't. It's not a summary judgment thing, but it goes to basically whether or not there's a substantial likelihood of success on the merits of the case as pleaded by the party that's asking for the injunctive relief. It also notes whether or not when a judge is thinking about issuing some sort of injunctive relief, 2 other factors, along with the substantial likelihood of success on the merits of the substantial threat of irreparable harm to the party that's asking for the injunction because they're trying to protect themselves from the irreparable harm, firearm, as well as the balance of the hardships that weighs in their favor, and of course the issuance of the injunction shall not be disservice to the public interest. So there's a little bit of an interest balancing test there. And if you want to see me go into a longer video about all that, let me know. But otherwise, again, we continue to move on. What the judge is going to hone in on here, and there's lots of different things that we could be talking about, but I really just want to kind of cherry pick a few of the big things because they're themes that we're seeing develop across a multitude of different cases. And when I see those themes develop, while there's lots of different rabbit holes we can go down, that's what I want to make sure you are updated on. So you can see the legal trends emerge because those trends turn into the battlegrounds, including, by the way, going from a recent case that just happened in Vanderstock v. Garland, where court struck down, the same court struck down the issues surrounding frame receiver rule recently. Check out our video on that in the description box below. The ATF adjusted their legal strategy to that. So again, just making sure that all this stuff is an ongoing evolution. So we're talking about the Administrative Procedures Act, which I understand for 99% of you, that's going to be super boring, the APA, the Administrative Procedures Act. I promise this is going to be short. The Administrative Procedures Act instructs the court to hold unlawful and to set aside agency action found to be in excess of statutory jurisdiction, authority, or limitations. Broadly speaking, Congress can pass a bill into law which becomes a statute. The interpretation and enforcement of those statutes basically get delegated to different federal agencies, such as the ATF when we're talking about firearms usually. So the ATF can then basically develop their own code, rulings, all that kind of stuff on how we're going to interpret the statutory authority, but they may not exceed the statutory authority, jurisdiction, and limitations involved. So they can reinterpret that, or they can interpret the statute, but they cannot exceed the statute. And that's where we're going with this, okay? The plaintiff, that's Polymer 80, contends that the ATF's final rule and its implementation of the regulation exceeds the agency's statutory authority under the plain language of the Gun Control Act, quote, because its redefinition of frame or receiver and treatment of parts kits are inconsistent with the Act's plain language, end quote. Why is that? Well, here's where we get to the court's analysis. The court says that Congress carefully defined its terms in the Gun Control Act. The primary definition of, quote, firearm in the Act contains three parts: any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. As a reminder, you can find that, by the way, at 18 USC 921 sub A sub 3 sub A. Under this primary definition, a firearm is first and foremost a weapon. Then, and pay attention to this because this is the crux, because the weapon parts also are not weapons, Congress created a secondary definition covering specific weapon parts, the frame or receiver of any such weapon. Congress did not cover all weapon parts, only frames and receivers, and only the frames and receivers of any such weapon that Congress described in the primary definition. All right, English. A weapon is a weapon. Frames and receivers are also weapons. The reason why they are weapons is because they are statutorily created by Congress and designated as Congress as a weapon. That's where the line is. The ATF is moving that line to say, well, these things are also frames and receivers, and now they're okay because now they're also weapons. That's where the court's getting hung up on this, at least as to this particular point. Congress did not define the phrase frame or receiver, so the words receive their ordinary meaning under the law. This is where the court differs with the ATF. The ATF is trying to then further define frame or receiver, and the court says, no, you can't do that. Done. Flag is out, whistle's blown. In the final rule, the ATF interprets the phrase as two separate parts, which we already covered, but briefly again, the ATF says that the term frame means the part of the handgun and provides the housing or the structure for the component, i.e., sear, things like that. Designed to hold the hammer, the striker, the bolt, whatever it is that we're talking about for that particular firearm in order to initiate the firing sequence. The ATF defines receiver similarly, though it says the term refers specifically to a rifle, shotgun, or projectile weapon other than a handgun. So what's the problem with this final rule? How do we tie this whole thing together into a non-confusing bow? The ATF added an entirely new section, expanding its jurisdiction to include partially complete, disassembled, or non-functional frames or receivers. The ATF now claims authority to regulate parts that are designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver. The parts must be clearly identifiable as an unfinished component part of a weapon. In deciding whether something is partially complete, frame or receiver, the ATF may consider those materials, again, such as molds, instructions, marking materials, and so forth, that are sold, distributed, or possessed. The court ruled, quote, "The final rule's redefinition of frame or receiver conflicts with the statute's plain meaning. The definition of firearm in the Gun Control Act does not cover all firearm parts. It covers specifically the frame or receiver of any such weapon that Congress defined as a firearm." End quote. That which may become a receiver is not itself a receiver. The line is there, according to this court. Now, notably, although I already touched on it, you can check out our video in the description box below. This is not the only frame receiver case. Vanderstock v. Garland's another one. And in that particular case, and again, this is where you see kind of the march and the evolution of case law here as different sides react to different trends. If someone loses a particular battle in Battle 1, they're not going to fight the exact same strategy. That's how you lose. And the ATF learned this, and that's the reason why they're pivoting. So the ATF, in their argument as to why the court should not grant this injunction, they said, look, the court concluded that the rule's amended definition of frame or receiver likely exceeded the ATF's statutory authority in that other case because it would regulate a component as a frame or receiver even after the ATF determined that the component in question is not a frame or receiver. So in Vanderstock, part of the issue there was the fact that the ATF initially said that is not a frame or receiver, therefore, we lose because we cannot move the definition of what is a frame or receiver. So in other words, again, I'm trying to make this stuff into English as best as I can. In Vanderstock, the ATF lost because they said initially, this is not a frame or receiver, but we're going to treat it like a frame or receiver because ruling. In this case, they're saying this is a frame or receiver, even though it's not a final frame or receiver. That's the distinguishing factor here. Here, the ATF is saying, no, that partially complete receiver, that's a receiver, as opposed to saying it's not a receiver, but it's going to become a receiver. Yes, those little semantics and legal sleight of hands that we see coming up all the time. The court orders that defendants and their officers, agents, servants, and employees are enjoined from implementing or enforcing against Polymer 80 Incorporated or its customers in any manner the provisions basically contained as part of the ruling. And that's where we're at. Just because something may become a firearm doesn't mean that it's a firearm. And something that surprised me a little bit here was the fact that we did not see the court allude to the Thompson Center case, which is a discussion about a U.S. Supreme Court case from the early 90s that you can see linked in our description box below. But it's basically a case where the court determined when parts become guns, and in particular, if you have a short barrel along with some components that could turn that short barrel into an unregistered SBR, or could be configured into a lawful pistol, when that's going to be legal and when that's going to be illegal, because the U.S. Supreme Court spoke on this subject. I was a little bit surprised to not see this come up here. Now, it of course remains to be seen exactly how much in conflict the ATF decides to enforce this rule, because it might impact Polymer 80. We'll also have to see whether or not things wind up getting appealed, because invariably they will. If you want us to follow this thread to see if the ATF violates this court order, let us know in the comment field below, and also feel free to head on over to the Tom Grieve channel as well. Don't forget, there's that free giveaway going on right now. It ends really soon. I have met multiple people at expos and so forth who have told me they have won these things. It is very, very real for what it's worth. We will see you in the next one.